reasons, but now, yesterday I have cleared all the memos.
So I have.
So this is what I remember.
I have verified that. I am mentioned always.
Huh?
I have verified.
When did you verify? Today? Because yesterday he was not there.
Yes, sir.
Yes.
It is not possible.
It is.
It's not. Yes.
So what in fact, last evening I have cleared all memos of all the 3 days.
I got it.
What are you check for you?
Give your statement.
I beg your pardon, my lord. I beg your pardon.
I'm constrained to move your lord. That mother is have filed this document. Your lordship kindly see that the boy is MCA student is in custody. So interim application may be cancelled.
You could have mentioned before appropriate bench.
So that has not been considered. So
It's not.
I humbly pray because
Is it a tied up matter?
I had already heard by
No. It's been earlier rejected, so
No,
that it has to be listed before that bench.
See, this will be improper on our part. All right.
I-
We should not
I
do it.
beg-
Persuade the, I know, and it is. Give your sleeve, we will see.
Obliged. Grateful.
There's one urgent matter, since regarding the pharmacy NOC that you're supposed to get. So in our case, what had happened is initially the document was not given by the state government, later it did. And within time, we have also complied with it. They sat over the matter, that's why we are here before your lordships. But there's a short period, the administration would,
So where is your memo? Give your memo.
your lordships, if I'm like this early hearing, so that your lordships.
Give your memo, I will see.
Well, hospital was seized by the authority for want of NOC, higher NOC.
Madam, is it a fresh matter?
These are listed before this Honorable Justice BP.
Fresh.
Honorable Justice BP Satpathy, and he had returned it because want of assignment. Let it be listed as of assignment. Well, tomorrow, it's an urgent.
Lord, may I mention a matter with my lord's indulgence?
Just a minute, Mr. Just a minute.
It was specifically urgent. Would not be listed, but
It will be
covered
listed.
by my lord's W order.
It will be listed. It will be listed.
I have increased the order.
Give your slip, please. Any others? Yes, Mr.
Lord, I had sought my lord's indulgence to mention a writ petition yesterday, 30390 of 25. My lord, that 1 week period expires today. They can take coercive action tomorrow. Memo has been given.
All the memos, I have passed some order that can be verified by the.
My lord, only one humble request, my lord. I am already there tomorrow. If it can come up tomorrow, I'll be most grateful.
Not possible, Mr. Jain. Some order has been passed in that slip.
My lord, the same similar issue, your lordships have passed orders and that period expires today. Kindly have it tomorrow. My
Check
lord.
up with what date has been given.
Date has been
Yes.
given, Mr. Jain.
My lord, in case there's some change, may I mention at lunch, just after lunch, I'll check up and in case required, I'll be grateful, my lord.
Yes.
Grateful.
10 December, it is coming on 10 December.
My lord,
Sure.
my lord, that 1 week expires today, my lord. Kindly accommodate us tomorrow. I'll be very grateful, my lord.
Very difficult, Mr. Jain. Tomorrow.
My lord, 5 minutes by the watch.
So many things are happening tomorrow here. We are otherwise.
My lord, I'm before my lords tomorrow in any case in the matter which your lordships have listed. That's why I was requesting.
Let us see.
They said at
Not
2
important.
PM.
Grateful.
I beg your pardon, my lord.
Yes.
It is a single bench BLPL matter, my lord. It's so urgent. I am bound to mention
Give
here.
us levers.
My lord, matter is just
Madam, please give your memo writing your urgency, it will be checked.
this is the tied up matter, Honorable Madam Ratha Madam. So
All right.
he's
It will
not.
be listed.
His son is died on
All
30th.
right.
Okay, you give the memo, it will come up on Friday.
Friday is too late, my lord.
Then what will I do? I can't take it up. to the division bench.
Only interim prayer, my lord.
What
Any other bench, if
All right.
possible, today, 2 p.m.
matter?
Tomorrow.
Oblige, deeply oblige.
Yes,
This is a fresh contempt matter. Division
10:30 का
division bench contempt matter.
give us a
ସେ ଗୋଟେ ହେଲା 10:30 ବେଳେ ସିଙ୍ଗଲ ବେଞ୍ଚ ଖାଲି ଡିଆର କହିକି 10:30 ବେଳେ ସେ ମ୍ୟାଟର ରେଜିଷ୍ଟର କରିଛନ୍ତି ହେଲା। ଯଦି ଡିଆର କିଛି ନଜରକୁ ଆଣିଲେ କି
Matters under the heading for orders, item number 6.
May I please, my lord? My lord, I pray your lordship may grant me 1 week time for the certified copy will file and delay the 89 days delay. Not preparing the appeal.
In this case, I'm appearing for respondents. The copy of the return bill has not yet been submitted.
And I'll start in course of the day.
You should have the opportunity of seeing.
yes.
You should have this opportunity of seeing the application, writ appeal and the conversion application.
Well,
Give everyone.
I'll give it in course of the day.
Mr. Bimbisar Das, learned additional government advocate, undertakes to file the certified copy of the, please write it in that IA. Certified copy of the impugn order within.
1 week. 1 week.
What is the use of granting you time if all the time you ask
नहीं,
1 week?
it
It
is-
दिया है नहीं.
It I've done.
All right. So he's appeared sumo to.
Yes.
Okay. And undertakes to file the certified copy of the impugn order within 1 week. The normal order which is undertakes to file, all right. IA for condonation of delay, Mr. S.P. Jena and Associates, Mr. S.P. Jena, learned counsel and associates have waiving notice have appeared in the have appeared for sole respondent. For the sole respondent.
Respondent number 1.
Okay, respondent number 1. Please check if it is. Mr. Das, please let me know. A copy of the IA for condonation of delay, as well as the copy of the writ appeal may be served on your Mr. Vera.
Swayam Prabhu Jana.
Mr. S.P. Jena, learned counsel, appearing on behalf of the respondent number 1.
Yes, madam.
By
Tomorrow. Or in course of the day also I can give.
in course of the day, please collect.
Respondent is 1. Thereafter
Okay.
6.
List the case on 11/12/2024. Yes.
Item number 7.
7, my lord, again, I'll pray your lordship may kindly grant me 1 week time for the certified copy coming for the first time.
All right.
133 days delay in approaching.
185.
185 days.
Just check. ठीक है देख ले. 185 ना 33. Says IA for this
180.
185. Just so it is same order. IA for condonation of and list the case on 11/12/2024. Yes.
Your lordship may kindly remember this is that sort of corridor case.
Yes.
Block grant employee, whether they will be
Yes. So the matters are being listed on 10th or
10th possibly. 10th.
okay. So list the case on 10th for them. Hello. Okay.
Item number 8.
IA for condonation of delay list on 10th. for them.
Item 8.
Item 8, my lord, for certified copy, your lordship may kindly grant me 1.
Nityananda Biswal, any
Again.
the job contracts. So any idea when the connected matters are there?
10th, possibly 10th.
That is also 10th. Nahi to? Bharat Chandra Gulja was the 10th. Job contract maybe anyway he'll see. IA dispensing with certified copy, same order. Condonation of delay,
1.
list on 11/12/2024. ये देखिए कि लखी देते हुए so that we can fix the matters accordingly. Yes.
Item number 9.
Not 1 week to file the certificate copy, then delay up to 56 days.
Permitted to file the certified copy.
1 week for certified.
In
Yes.
fact, what we would suggest, this for the Office of the Advocate General, that in all the cases, you please apply for certified copy today itself. And you will get certified copies tomorrow or by Monday.
That is what I have advised him, and in many cases you have to file within 2 days getting the copy by file. In other cases, I have also instructed the sections to
This I
online to apply
have
online.
suggested 2-3 weeks back.
In each and every case, we are passing this order
Yes.
that is not required at all.
Wastage of court's time also.
1 week I have to file. 1 week.
Yes, that is there, but waste of time. Doing that order will be passed, then you'll file, then we'll say filed. Anyway, IS, same order, list the case on 11/12/2024.
Item number 10.
10, my lord, some defects are there and certified copy. For both the things, removal of defect and certified copy, one more time, your lordship kindly grant me.
Mr. 9 re Mr. Kesikar, 10 re Mr. Bimbisar Das, and additional government advocate undertakes to remove the defects pointed out by the stamp reporter within 1 week, full stop. ତାପରେ I8 remove 1 week, list the case on 11/12/2024. ତାପରେ I8 same order.
Item 11.
And this is also a Sharad Parida case. Item 11 also Sharad Parida. 10, 11 both.
10, 11, there's 2, 3 more, I think. Anyway, same order in 11.
Item 12.
Wanted to file certificate delay of 422 days, madam.
I think this has been disposed of after filing of counter affidavit. This item 12, so 425 days. Anyway, you file the certified copy. Same order, list on 11. Khali se dispensing with one week time. Yes.
Item 13.
That's delay of 13 and 14 same issues, a delay of 242 days in both the matters. And the issue is whether the director of learned single judge to regularize
Health worker. That I think similar matter was listed yesterday or day before.
this.
No, health worker was there. Mr. Das may remember. Mr. Das, I think health worker, multi-purpose health workers was listed yesterday or day before.
Day before, those have been posted to 7 January. Possible.
After issuing notice.
Yes.
All right, could you confirm the date, please, later? Check kari koi debe?
Yes.
All right. It a condemnation of delay, issue notice. Order be passed and that same order. In the condemnation of delay only notice will go. But post it on the date when similar matters are listed. So accordingly, 4 weeks or enough. Returnable within 4 weeks. The issue notice on the question of condemnation of delay, returnable within 4 weeks. Requisites for which shall be filed by today's 4th by 9/12/2024. List on, most probably you are saying 9th. Mr. Das, kepe koile 10th.
7th.
Most probably 7th. Okay, it date not deliver, it list on 7/1/2025 when similar matters have been directed to be have been posted. Yes. Same order in 14.
Item 14. Item 15.
That's delay of 621 days and request 1 week time for filing certified.
All right, 1 week time in the IA, list on 11/12.
Item 16.
16, my lord. Certified copy you have not filed. You are also kindly grant us 1 week.
Again, 11/12, that IA is disposed of. Yes.
Item note 17.
17 delay 261 days. Certified copy you have not given.
Again, 11/12, that IA is disposed of.
Item 18.
And that's 18 and 19 issues are similar, but in 18 the delay is 54 days and 19 41 days. Issue is relating to
Sarat Chandra Parida. So, okay.
And 1 week for certified.
For both you need certified copy. Okay. You file the certified copy, let us list it on 10th when similar matters are there, so that if another date is fixed, you can do it. So I is disposed of, granting time till 10th. Time till 9. Please try. Time till 9th. 9/12/2024, filing of certified copy, list on 10/12/2024 when similar matters are stated to be posted. All right. Both.
Item 19.
Same.
19 is same.
Item 20.
20, my lord. 108 days delay in approaching your lordship in this appeal.
So this some okay. This is a different matter, I think. Selection matter regarding award of marks.
Qualification has been changed in notification that has been challenged.
All right. Issue notice. 6 weeks. Which date?
22nd January.
Okay. So issue notice on a matter of condemnation of delay, return within 4 weeks. Requisites order list on 22/1/2025. All right.
Item 21.
21, my lord, there is a delay of 60 days. Certified copy also we are required to give it
Alright.
within 1 week.
So if
My
I
learned,
dispose of copy on the 60 days delay. 11.
my learned friend Mr. Jaina gave me 2 orders
Yes.
saying that this is a covered. So
That day you show
let
us?
me go through. Yes.
11, 12, 11, 12. Yes. I had disposed of this dispensing with.
Item 22.
Delay of my lord 56 days, 182 the certified. copy.
Okay, again 11, 12, that delay, that I is disposed of.
Item 23.
This is that matter where I have taken off location as special machine. And this is that sale of calibrated iron ore. I was a successful bidder. 4,021 metric ton of iron ore. I have deposited the entire cost. But I could not lift it almost 50% of some natural calamities, heavy rain and other things. I applied for it.
When did we pass the order? Why did he go on a Sunday to deliver notice in the office? Let me see.
Yes, special machine on Sunday.
This office was closed on 10th. It has to be closed. It's a Sunday.
Now that issue has lost its relevance.
Okay.
The reason being that successful bidder did not also deposit. Thereafter, they went after receiving notice from your lordship, they went for a third auction. Now the third auction bidder came, he deposited the entire amount and lifted the quantity also. Now during pendency of the petition, despite the matter is pending, after receiving notice from your lordship, they went for third auction and the bidder came out, some other person came. I have applied for amendment also. That is flag D. Now the development is the third auction to my instruction has lifted the quantity. So has lifted the entire quantity. So I'll be requesting my lords, either if they can permit me to lift the matching quantity of existing quantity from them, or lordship will consider refund.
That'll be a final order.
Naturally.
So you want to amend?
I have to amend, and flag D is the amendment of it.
My lord, I am for OP1, my lord. I have no objection for the amendment. That is, I
Have you filed any application for amendment?
I have already filed the application for amendment flag D.
And also they have filed also the consolidated appeal. I don't have any objection to that. But regarding IN number 1500, 1718, I shall file the objection affidavit, my lord, because they have, because unless that is accepted, this has no force. So I am filing.
No, you have already filed a counter affidavit.
My lord, I have filed the counter affidavit and the objection affidavit. Everything I have.
No, IA for amendment, appropriate order. That is the IA.
That is the IA.
Sure. Are you sure?
Flag D is the product.
Like,
That IA number 15719 of 2020.
Right.
I have only formally wanted to incorporate that hard auction notice and implement that auction procedure as a.
yes, sir. This IA has IA number 14285 of 2024. This IA has been filed with a prayer to delete paragraph 1 and 2 of the substitute paragraph 1 and 2 of the writ application by substituting it with a new paragraph and amending the prayer in view of subsequent developments which have taken place after filing of the writ application. Mr. Senapati.
My lord.
Mr. Senapati, learned counsel, who has appeared on behalf of the opposite party number 1, has no objection.
1 and 2 both, my lord.
Okay,
1 has given the counter.
Who has appeared on behalf of opposite
One
party
and two.
1 and 2 has no objection to the said amendment, but he prays for time to file an affidavit in reply to the amended writ application.
No, my lord.
No, you don't want to file a
No,
counter.
no, I have no objection to that. But regarding other I shall.
My lord is saying, consolidated petition, whether you would like to file objection.
No.
You don't want
No.
to. All right.
No, my lord. On
All right. Other IA, we are not passing any
No,
order.
No, my lord. On consolidated, my lord, I shall file this. Counter affidavit. I shall amend my counter affidavit.
You can file an additional affidavit.
That
It's up to you. Either you
My-
file
Instead of amending it, letting file it.
better you file another affidavit, including everything, so that
My
it will
lord.
be easier. All right. Has no objection to the amendment which is sought for by the petitioner. but submits that he may be given a chance to file an additional oblique consolidated counter affidavit. All right.
Well,
Now it's okay.
well,
All right. List the case on.
well, regarding a higher number.
I am not passing any order. Why are you want me to
Well,
pass some interim
well,
order?
Sorry.
List the case on 11/12/2024. In the meanwhile, a copy of the consolidated writ application may be served on the opposite parties, on the counsel appearing on behalf of the opposite parties. What is that I? So,
But I have some interim periods are there, your lordship will consider on that, it not be considered.
all right.
Well, I can find the objection.
Objection, if any, be
My left friend is becoming a.
consolidated writ application you serve today then. All right, so that he can file a count before the next date.
Yeah.
He has already received.
All right, then you file your whatever affidavit you want by 10th.
Well,
All right, file the 10th after serving copy on the learned counsel for the petitioner. All right,
well,
the counter consolidated oblique additional counter affidavit, if any, shall be scanned and incorporated in the digital record.
That's it.
All right. You file it by 10th, then it can be incorporated in the record. All right, you replied.
Item number 1.
My lord, in item 1, your lordship yesterday directed me to take instruction as to what is the length of time you require for the purpose of reconstitution of the governing body. I was talking to the director. They require 45 days.
5 days.
Because of nominee of various public officials, that may, your lordship may grant me 30 days time. He was saying it may take a longer time, 45 days. The lordship may grant me 30 days time.
No, we will not grant you time like that. We will pass an order. We will have to decide the matter.
Yes, ma'am.
And then only we can direct. We will have to consider. But if that is your stand, then we will be constituting a committee. We will constitute a committee. This committee will not continue. We shall constitute a committee. Because you are not in a position to do that. We will do.
No, the lordship directors will.
You can appoint, whether you can appoint a person, an officer or not. Like you had done earlier, ADM or something.
Yes, ADM was appointed.
So that can be done.
Yes, my lord, that can be done in very short span.
All right. So we will pass orders and then you can do that instead of. We will give you time to reconstitute, and in the meanwhile you can appoint an officer.
Yes, my lord. Yes, my lord.
We will give you time.
Yes.
We will give the time within which you will be required to reconstitute the committee. These are.
While you constitute, the officer can remain in charge, but subject to order which will be passed.
This is the
He will be appointed.
what is there in our mind. Finally,
somebody will.
There in my rate appeal as a particular order, this body which does not de jure exist for the submission had removed me. That's
first of all, let us pass order on that.
The principal part of it. The principal actually, I mean, our college needs to have a principal. So that's my only submission. That's what I had tried to impress upon you, the court, is that this de jure does not exist. She could not have exercised any powers under the statute, the act, and whereas the rules. So my removal, and that's the reason also my removal is back. And to that extent, also the single judge judgment.
Do you have any forum under the law where you can go other than writ jurisdiction? Like whether the director has any jurisdiction, the tribunal has any jurisdiction. No such body.
For this matter, it would be here. For this particular matter, it would be here.
No, this particular it would be here also because this is writ appeal, which arises out of writ petition. So the question is whether that aspect can be addressed by any other
law. There is no such provision. There is no such provision.
There is no such provision.
And there is significance actually because the principal also becomes the ex officio member of the body. And for ex officio members, there is actually no terms. These can be for more than 2 terms or 3 terms, whatever may be. So that was there also significant. Why did they do that? If they wanted to remove and put their own man there.
But if I'm not mistaken, the single judge has set aside that order removing you.
Yes, but
not directed for your reinstatement. So that is your
allow
grievance.
some other person from some other university to remain in charge.
So now you are agreed by the order of the single judge because
Yes, only to that extent.
Yes,
That
so their appointment that has been set aside.
Only that I should be put back.
So on that ground that he did not have the power to do it.
They did not have the power.
No, that is the order of the single judge.
Yes. And also that fact that consequently I should come back. What the single judge did is it actually cited a judgment, wrong judgment, to not allow me to, not to give me the
No, there are 2,
consequence.
3 judgments. There is, we have 2 judgments also. I'm trying to look for it. Mr. Rautre was there. I'm not getting the reference.
Because I think that the important thing is this college needs to have
order. One with the short orders. Rautre was there.
My lord was there. My
All
lord.
right, we'll pass orders
college needs to have
on 18th on
somebody in charge.
On 18th, we will pass order on this article. The constitution of committee and a governing body. And then, depending on what we decide, we will consider your offense.
In the meantime, we need not go for appointing any.
No, unless you get an order, how can you go for that?
Yes, ma'am.
Unless the court directs you,
Yeah.
you cannot do that.
Yeah, what's
Permits you, grants you liberty. Huh?
ADM in charge.
Was after the question of the not before that.
Today, if your lordship is kind enough to put the college in the hands of some safe person, I would do it.
No,
Because your lordship, what is happening?
see, madam, I have done that. I would have constituted the governing body. By judicial order, the governing body with qualified people would have been considered. But because there is power where the state government can appoint an officer also, then let that power be exercised. Had there been no option, then the matter would have been different. But there is some,
that is
so we should not preempt their restrictions.
Our only information is that yesterday also this governing body has taken up past resolutions, removed people, extended people. So it is this, if the ADM immediately comes, at least this governing body is not doing anything to the college and its funds.
On 18th.
And its funds. Who wants to be in power unless there are no funds there?
On 18th. Same heading. Okay. Financial transaction. Any action taken by the present governing body shall be subject to any order passed by this court. In the meanwhile, yes.
Press admission item number 2.
Next week, on his legs.
Mr. Biswal, I had asked Mr. Rautre, could you just help us? We have passed an order regarding posting of this principal from the neighboring district or something in charge in his case. So I could not get the proper reference.
By lunch, I will provide that.
Thank you. Please give it to the court master.
The impure order is annexure 1.
Item 2.
My lord.
Yes, what is wrong? See, as we have understood, it is not a question of raising claim for financial benefits belatedly. It's a question that they were entitled to grantee name.
Madam.
And that was decided later. But in the decision, you mentioned that they will be entitled for only 3 years.
Taking recourse to the judgment rendered by the Honorable Supreme Court in the case of Tarsem.
Same thing, because there the claim was
16 years after the 16 years.
In that
after.
case, no, in Tarsem Singh, the claim was belated.
Yes,
If
that's
you
right.
demonstrate in this case that the claim was belated, then it's a different matter.
Yes, I understand.
Claim was not belated.
Not belated here.
Therefore, your decision following Tarsem Singh, so it has been rightly distinguished by the learned Singh in that.
With Lordship's permission, a similar matter has also been discussed by this honorable regional bench. On the same context, it was appealed by the honorable appeals court also.
What you're saying in the record is that.
It is there.
You've given,
I find my objection.
in the second case.
Second case.
Okay. The first one, nobody is appearing for the respondent.
It's a similar case, you know.
Understood. We can also dispose of in the absence also. In your second.
That part your lordship is correct. To another thing, he was granted that benefit, thereafter it was withdrawn.
Withdrawn.
There also is not been.
Copies of the matter, lordship want to pay with that.
So what you're saying, it has been dismissed in the Supreme Court.
I'm sorry.
No, where is the decision of the High Court?
It is there.
No, that was dismissed on the ground of
Limitation.
limitation. That is not considered. We shall address it on merits.
Madam.
I paid
On merits, we are not satisfied.
Page number 17, the reference of that case is clear. Understand you.
What?
The question of law has been kept open. I do understand. But
You understand, you should have made small mention about that.
So let us have the facts, dates.
Mr. Biswal, again, this is on limitation and Supreme Court has left the
Your
question
Lord.
open.
Yes,
So
your
how
Lord.
does it help you?
because all the three matters were heard jointly, and even that the issue of the honorable the division bench of it's on page number 17. The same petitioners are there, your Lordship.
So where is the order impugned? Order of the state government?
Okay. Oh, so we were looking for this Rashmi Ranjan Das, so this is the case, okay. State government order is at
And then
Annex 3. Annex 3?
it must be in the petition, your Lordship.
No, writ appeal also it is there. Annex 3 probably order dated 21/6/2019.
You cannot apply Tarsem Singh. Court can apply Tarsem Singh.
I can very well understand that.
First one लेकिन respondent पे none. अब common order पे करते हो?
Tarsem Singh. नोट कर लोगे? Distinguished Arsene Singh. 2008 volume 8 SCC 64. Yes.
Item number 3.
Lord, with regards to the rehabilitation, apparently last time, your lordship had granted us time to know from Supreme Court. From the connected matter in which stay order has been granted by Supreme Court. So Sasudas Deliganda had asked her, let it adjourn 1 week after or 3 and 4.
Because it is a question of law which is to be decided. See, in our opinion, Malayalam Setti does not lay down a law.
Yes.
So the court has, Supreme Court granted relief in that case in peculiar facts and circumstances. That is Malayalam Setti does not rule that the rule applicable at the time of death shall apply. There is no conclusive finding recorded by the. We will see.
I will find out.
He's not there today.
My lord?
Mr. Das is not there today.
Come 1 week, 3 and 4 both.
As
Three and
requested
four.
on behalf of the appellant, these matters on.
That's the right appeal number 895 of 24. Similar matter will be taken up with this one.
3 Thank you.
We list these matters on 2 weeks along with WA number 895 of 2024, which according to learned counsel for the respondent
Punishment 989
involves similar issue.
3 is connected with 989 of 24.
You are appearing, and that is already in the list. What are you? Which matter are you appearing?
The matter of saying by case WBC 933 of 24.
There's no WPC here.
WA 933 of 24.
You are Mr. SG Das.
Yes, ma'am.
Likhi do Mr. SG.
Right, I request that W number 895, similar matter will be taken up along with this matter.
All right.
Already order has been passed. Now would take order appearing.
Item 4.
My lord,
Item 4. Sorry.
my lord,
Before I take your notice to the improved order, I just show a couple of pages of the earlier orders which have been passed. Your notice may come to page 15.
my lord, before my learned friend starts, may I submit one thing in item 3. The lordship was asking about the judgment. I located a judgment rendered by 3 honorable judges of the Supreme Court on the same question, but the matter relates to Bangalore, Karnataka. But their lordships have observed date of consideration is the 3 judgment.
That was, it seems that was under consideration in Malayalam City also.
Yes.
But peculiar facts. So what is that decision, Santosh?
NC something.
Yes.
Yes, that has been taken over.
That is in that decision. Therefore, the Supreme Court held that peculiar facts and circumstances. Therefore, Malayalam City does not lay down a law.
Yes.
And that is yet to be decided.
Yes.
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 Please, you are.
Yes. Come to page 59, which was an order passed by the NGT. The effective portion of it is at para 50 of that order, page 59 of the bill.
Just a Yes.
May please. Sorry.
Yes.
The respondent shall also initiate criminal proceeding against the then Tahsildar so-and-so, so-and-so, and for unilaterally taken the decision for option of query, ignoring the subject record of right, so-and-so, and all that, right, to lodge FIR. This order was challenged in 2 writ petitions. If I take your lordships to the first writ petition, which my lord order starts from page 63, but the effective portion is at 69.
Yes.
Last, para 4, after 5 lines, 3 lines, this court finds that the committee constituted by the NGT has violated the principles of natural justice by not affording the petitioner an opportunity of hearing. In such view of the matter, while setting aside the impugned order dated so and so, this court remits back the matter to the NGT for adjudication of the issue afresh. It is also made clear that committee constituted by the NGT so and so shall afford the petitioner a reasonable opportunity. Then this order was again reiterated in the subsequent another writ petition, which was filed by the present petitioner himself, which is at my lord page 73.
Yes.
Para 4, if you considering the submissions made by the senior advocate appearing on behalf of the petitioner, and since the issues involved herein has already been adjudicated in WPC so and so, the earlier order below.
Yeah.
By setting aside the impugned order so and so, this court remits back the matter to the learned AGP so and so. Again, the same issue was. Then, my lord, they issued a charge sheet against me, department, which I challenged. If I take your lordships to that imputation of misconduct, is at page 78. Imputation of statement of imputation.
Who are you?
My lord, I am this Sanjay Kumar Samanta, who is an OS officer. So, NGT directed of initiation of action against me, along with others. So, if your lordship should see.
So, whether you were party in that case?
No, my lord. In the NGT, we were not. That is why it was.
So, you are challenging disciplinary action?
Action based on the very same order which has already been set aside by this honorable.
Till that, you cannot see quashing of the departmental proceedings. See, these are two entirely different things. After having seen the order passed by the Grand Tribunal and the order passed by this court also, the employer has a right to reach a conclusion, may reach a conclusion.
But I'll just take your lordships to the impugned order, where because I went against the disciplinary proceeding, but the order which has been passed is regarding the criminal proceeding, which is not, I have not challenged that because that is a subject matter of a different proceeding altogether. So the departmental proceeding, which is based on that very same order.
It is different. See, the order was illegal.
Yes.
Was found to be illegal. Therefore, that has been set aside. But your conduct still can be gone into by your employer.
No, but that has not been done. Because here what has been done is because of that direction by the NGT. If your lordship should see that page 78.
So this plea you can take before your employer.
But once they have initiated.
No. You can see, this is, you can file your, we are not here to advise you, but you know it better that you can file your, take this plea. Let's see, you are relying on this. This has been set aside. Why should you initiate departmental proceeding? They may say that no, the charges are otherwise because of these facts. We don't know.
Because the very, I understand what your lordships are saying, but the very fact that the entire issue has been taken from that order.
No, whatever, these things are to be, and what is the order impute?
Yes.
In the,
I made a, because against this I made a representation. Initially when they issued, Lord, I made a representation before them stating the very same thing.
Are you challenging Annexure 5?
No, Annexure 1, Lord.
Annexure 1.
Which is the, Lord, both, my Lord, this
what is your name?
Of, Lord, the memorandum of charges as well as Annexure 1, which is the Honorable Single Judge's order. If your lordships will come to page, it starts from page 721. Page 21. If
you have challenged what?
1 and 5.
1 and 5.
In the writ appeal. 1 is the Honorable Single Judge's order and 5 is the memorandum of charges which has been issued against. And your lordships may come to Annexure 11. The appointment of the inquiry officer, because I gave them that very same, your lordships, what your lordships stated in my so cause. They have rejected that and they have now appointed an inquiry officer.
Washing off disciplinary unless you show that no misconduct is made out at all.
My lord, that I could have shown when if I had been given the opportunity by NGT. Now NGT has passed an order.
NGT, how can you? How could you appear before the NGT? You are not a party.
That is why, my lord, when the NGT passed that order, the Honorable High Court in the first two orders said that the NGT's committee should give me an opportunity. There I could have placed the matter. Had there been an objection against that, then the proceeding could have withstood the scrutiny of law. Now that, my lord, that has not been done at all. Now this has been passed and now they have gone ahead with the proceedings.
You can take all the plea which you are taking here.
I have already taken, I have given my so-called. After that, they have appointed the inquiry
They are
officer.
duty bound to consider all your defense, which you take in the discipline. See, the employer has also.
The lordships may see page 84.
First
That is
page.
my reply, which I had given.
Who had filed the writ petition?
I had filed the earlier
No,
one.
no, that in which the tribunal's order was set aside.
I was one of the petitioner, the second writ petition. The first was by another Malod. The two writ petitions. The one at
So let us see the charge memo.
yes, ma'am. For imputation of misconduct, it pays 78 stars.
Yes, they are the charges.
So, my lord, even for that matter, the Paul Anthony case would apply because on the same set of my lord, facts, the criminal proceeding has been initiated.
No, the criminal proceeding. See, it is someone has not been acquitted.
No, man.
All right. So the whether the criminal proceeding has been quashed.
No, it has not been quashed.
That can be seen.
Because I have to disclose my defense in the disciplinary proceeding
That
also.
is old law, Mr.
Yes, my lord. That's why I said, my lord, Paul Anthony case, that's the reason.
Much water has flown.
Subsequent decisions are there also.
No,
After Paul
it
Anthony.
can, but unless it, my lord, works to the prejudice in the criminal case. There has been
now the principle is that different. The standard of proof
is different.
Standard of proof is different. Now, in one of the cases, you must have seen that because in the departmental inquiry, because the person was exonerated, the criminal case was quashed.
Is quashed, not the other way around. Not the other way around.
No, not the other way around, but even that proposition of law is under serious doubt.
Because the logic is that if preponderance of probability.
That was the
also
logic. So that was the
goes,
logic.
then there is no question of going beyond reasonable doubts.
We don't know what evidence would have been led in the criminal court, criminal trial, and
No, but we have to go by whatever the law is propounded by the courts.
The present intra-court appeal, the appellant has put to challenge an order passed by learned single judge of this court dated 28/10/2024 in WPC number 24614 of 2024, whereby the learned single judge has declined to interfere with
criminal proceeding. That is the Judicial also see that order. It has been mentioned as the criminal proceeding. That's why I said, my lord, because this is, I have not challenged the criminal proceeding per se.
Since it is the typographical error, no?
My lord, because the initial
Apparent. Hearing line to interfere with the disciplinary proceeding initiated against
Departmental.
initiated against the appellant. First off, the appellant is a member of Orissa. OFS.
OS office, Orissa Administrative Service.
Orissa Administrative Service.
And working as Tahsildar Dharmagar.
I think there is some level 1, 2 or something OS.
The
Junior.
Departmental proceeding was admittedly initiated in the wake of certain order passed by the National Green Tribunal, Calcutta bench, dated, what is the date?
But the disciplinary proceeding is 1/5.
No, what is the date of NGT or?
NGT order is 23, 18/4/2023.
18/4/2023 in
OA number, that would be
83 OA 83/2022/EZ bracket IA number 189/2022 again EZ. Page 22 it is there.
yes.
Senior counsel appearing on behalf of the petitioner has submitted, appellant has submitted that the said order of the tribunal has already been set aside by this court, and therefore initiation of departmental proceeding against the appellant is not at all justified.
In persons of the criminal proceeding initiated based on that order. Because the charge memo of your lordship should see.
So that was the order.
Yes.
That was the order that included this also.
Yes.
Initiation of criminal proceeding. So he submits that the disciplinary proceeding has apparently been initiated in the light of the NGT's direction to
initiate
criminal case, to register a criminal case for certain violations. So he submits that the appellant was not a party before the NGT, and in any case, the order having been set aside, order of the tribunal having been set aside, comma, no departmental proceeding would have been initiated based on the said order of the tribunal. So next.
So party
have-
but not heard.
No.
Tahsildar
In
Rampur.
the proceeding, yes. Tahsildar was a, but we were
Tahsildar
not
by
heard, we were
post.
not noticed.
Yeah. that is not heard.
And then Tahsildar by post.
Yes.
The next we have reviewed the impugned order and the charged memo served upon the appellant for initiation of departmental proceeding. First off, the charge memo do contain allegation of misconduct against the appellant. Stop. It is, however, submission by senior counsel for the appellant that the allegations are based on the same set of facts
On the basis of which the criminal.
based on which the tribunal's order was passed. So stop. Next. In our considered opinion, when single judge rightly declined to interfere with the disciplinary proceeding, full stop. The plea which the petitioner appellant has taken in the writ proceeding as well as in the present intra-court appeal are available to him to be taken in the departmental proceeding at appropriate stage. Full stop. It goes without saying that the observations made by the tribunal in its order, which has been set aside by this court, shall not prejudice the appellant's case in the departmental proceeding. Will that do? That order will not prejudice you in any manner.
And may be given an opportunity to present all the, the defense, whatever.
They are bound to follow. They are bound to follow. Therefore, there is next. There is current typographical error in paragraph 5 of the impugned order, wherein criminal quote unquote has been typed in place of disciplinary. Stop. We modify the said part of the order accordingly. Yes.
Item number 5.
In the morning, we have filed additional affidavit all the time. Every day. I will take hard copy.
Yes.
Validity period, over of the validity period of a tender. But that tender, they can extend the period and assign the work. But you see the affidavits. Like the affidavit which is in sub project. But you see, state is also not coming with a clean hands.
This time.
This time also. But you see the page 5, D2. Why I am saying, because I have got the information, that's why I am putting it in my note. Otherwise I could not put it. But you see annexure D by 2, which is 5 by.
first line which I am seeing is that during filing of the counter affidavit, inadvertently, certain vital material, fact, execution or agreement could not be brought to the notice of
The
the
counter
authority.
affidavit was filed on 18/11/2024.
Got quite.
And
Lordship will see before he, yes, your Lordship may see the order dated 8/10/2000.
Yes, no, I am looking at paragraph 4 of your affidavit.
Your Lordship, the order was that the result, whatever.
Yes, that is fine.
That
That is fine. That doesn't mean that whatever you have done, you will keep it, not inform the court that this has happened during.
Your Lordship, not
That we have to
intentional.
see.
Because it is an essential service, your Lordship, the laundry services. Even for some days also, they cannot close it because otherwise there's OTs will be closed. Your
We are not
Lordship.
there.
ICUs will be
We are not
closed.
there.
Yes, your Lordship. For that reason, it happened, your Lordship.
For that reason, you did not bring it to the
No, your
notice of
Lordship,
this court.
it was an inadvertent mistake, your Lordship. I have called on the officials, I have called them personally, your Lordship, and discussed with them. It's nothing intentional, your Lordship.
Only one thing, my lord, I want to brought to this notice. Let's see the annexure D/2, page 5, which is the agreement executed by the intervener and the tender authority.
What is wrong with it?
Yes, my lord. Let's see the first page.
What is wrong?
My lord, the back page they have not provided. Why they have not provided? Because reason that this paper was purchased on 10/10/2023 from Koraput Treasury. That information I have.
Oh, that behind
Back,
the
yes.
first page where they have
Back
the
page they have not
details.
provided. Even the state is also not coming into clean hand. Internal also filed this same thing as they have given. 10/10/2023.
Bar to enter into an agreement, your Lordship.
We are not there.
Whatever was
We are
there
not
was
there.
The only thing is
We are
that
not there.
Yes,
It
your
is
Lordship.
subject to result, so there is no
the
problem.
only
But
thing is that why such a backdate paper has been utilized on 17/10/2024, 1 year back. Because the order of lordships, originally order of the lordship. That's the reason. That's
why
the,
is the overreach?
because lordship passed the order on 8th.
There was no
Then
bar.
22nd, the matter was before the lordship. They said, time to taken that there is no information from the there. But again, they filed it. These things has not been brought to the record. And further inquiry, my lord, the paper was also not purchased from the treasury of the from the concerned stamp vendor on behalf of the present internal. Lordship may direct to seize the record, you lordship got it, everything.
That also must be inadvertent.
Lordship wants, I can.
So whether the service has been affected,
My lord,
in
no service has been affected.
Oh,
No,
oh,
sir.
oh. We had passed that status quo order.
Yes,
That
ma'am.
is why this agreement. Oh,
No, your
No, no.
Lordship, this agreement is much before that.
Okay.
The status
the
quo
last.
was
2023.
2011.
This order is 2000, agreement 2023.
No, ma'am.
No.
It's on 10th October 2024. 17th October, 17th October, the agreement was executed. Lordship, see, I have given that agreement.
20 November, your Lordship.
Status quo order is on 20th November.
but the agreement has been annexed. Why
Yes,
is
ma'am. Second page, they have not given it. The back page, they have not given it deliberately. Yes.
Why?
Lordship, see. But even if it is a.
Why? What is the difficulty?
My difficulty is that, Lordship, see that the date of the purchase is 10/10/2023. 1 year back paper has been utilized here.
And this has been purchased in
And from, which is from Koraput, which is 180 kilometers from the Kalahandri.
It's a backdated stamp paper, nothing wrong with it because the agreement is there, your Lordship. It has been signed on 17/10/2024.
Parties are not actually disputing
The signing parties are not
Not
disputing the
disputing.
purchase.
They will obviously not dispute. Why should they dispute when they have whatever he's alleging?
And this is pursuant to a tender call notice, your Lordship. It is not something that has been done on a negotiation basis.
Yes, obviously. An invitation to offer, he has made his offer.
He has
did
been
not-
rejected.
He did not come forward to validate his offer for consideration. Now, what is?
The validity period.
And further inquiry, my lord, I found, my
Because
lord,
it is an essential service, your
the
Lordship.
paper has
and-
not been purchased in name of the signatory.
So you can file a suit if dispute is
Is
of
that-
such nature.
now, such a thing has been going on.
No, right.
So one is that tender notice, my lord,
page 18, 2.6.
No, short point is that whether they could have extended the validity of the tender after expiry of the
Expiry of the
period.
period.
So that,
That is not
you
condition.
you address on that because we
Only.
made it subject to result. So you address on
Yes.
that.
Annexure 1 is the tender call notice.
So that they are not disputing that it is beyond the date.
Page 18, 2.6. The proposal shall remain valid for 180 days after the date of the bid opening. Any proposal which
So
is
when
valid,
was bid opened?
bid was opened on 13/2/2024. Technical bid was opened at 3:30 p.m.
That is the proposed date. There is nothing.
That is just. One minute, sir. It is in the counter, the state file that 13/2/2024 bid was opened, and he's saying that.
You are referring to what?
My lord, I am referring to page 18, annexure 1, 2.6 clause. 2.6 clause, my lord, specifically says the proposal shall remain valid for 180 days after the date of bid opening. Bid technical.
We are reading.
My lord,
Page 17.
last.
Page.
Page 18.
Page 18, okay.
2.6, my lord, clause 2.6, my lord. Last.
Yes.
Valid for 180 days.
180 days from
Okay.
Yes.
date of bid of company. My lord, 13/2/2024 was the last date of submission of technical and financial bid. 13/2/2024.
What is the date?
13/2/2024.
Yes. So it should have remained valid till.
My lord, it will remain valid till 12/8/2024.
Now show us from the counter where they admit that.
They admit, my lord.
Yes, show us that paragraph from the counter.
Para 7. Para 7, page 3 of their counter, they have stated that is humbly submitted that in request for proposal, which was provided by the state office for mechanized laundry services.
Neither the counter is there nor the additional counter is there. Additional counter filing today. Counter is not scanned, it is not there on record. How many have we taken? Last date we have seen the counter. There in the record. So here have I missed it?
Counter is not. When did you file?
19th, 11th, 2024.
Yes, matter was there on that date. Matter was listed on 27/11. We have seen the counter on that day. See, please see. Oh, it is paperless.
Paperless.
You filed it on 19/11. Unless we say bring it on record, they will not bring it on record. Tomorrow, let's send from.
All right. The counter affidavit which has been filed on behalf of the opposite party, the reputed state of Odisha, has not been.
Who has filed? State or Tahsildar? Who has filed the counter affidavit on 19/11? CDMO.
Is not there on a report. So, we'll discuss case
District Medical Officer, Your Lordship.
tomorrow under the same heading with an explanation from the concerned registrar as to why the said counter affidavit has not been placed on record.
Additional, you have filed today. That's also.
An additional counter affidavit has been filed today. You have filed. Has been filed today.
District
Behalf
Medical
of
Officer.
the, shown by the district medical officer. So, that the same be placed, same also be placed on record. Come on to
Digital.
Thursday.
Thursday, Your Lordship.
Or 11. 11.
Tuesday, Wednesday, 11.
11.
11.
11.
Then 10.
16.
Wedding.
Yes.
16th.
16.
Factor.
So both of you are praying for interim order to continue. Well, he says, suspended, you are saying it is already there.
I cannot afford the loss.
Yes.
Oh, no, interim order helped you.
I'm continuing there.
Yes.
That is the interest of meeting. That is the interest of meeting.
Yes.
In fact,
No wonder he did not object. Please keep it, you can.
Paper is not also not.
All right. You need not go into that if the law is in your favor.
For admission, item number 24.
24 readings are complete, my lord. Here, my lord, the case is that petitioner's limited grievances regarding refund of the bid amount deposited by the petition given the year 2012-13, my lord. My lord, here,
12-13.
2012-13.
Why have you come in 2022?
No, it's a continuing cause of action since he has been pursuing since 2012-13.
So could you have filed a money suit?
My lord, your lordship may kindly hear moment, then I leave it to your lordship's consideration. Look, it is an admitted fact that the query was never been allowed to operate by the petition. It has been also stated in the counter affidavit filed with the opposite parties in the earlier writ petition that he was pursuing. Lordship may kindly refer that case.
But why have you come in 2022?
Not 22, Balas. 2019, the direction of this honorable court was given to the collector to consider my representation in 2019. All three writ petitions that was filed with the petitioner were disposed of together, directing my representation to be considered in light of one case, my lord, covered by my case.
Yeah,
Then, my lord,
just one moment. So you had filed 3 writ applications in respect of 3 queries.
Same query, because during such time, my lords, I was given on negotiation basis. I deposited.
No, why 3 writ applications?
But during such time,
But one query.
One query only. Everything those have become redundant. Now only the question is regarding refund of the bid amount because it has never been allowed to operate. Then the collector, my lords, under Annexure 3 has passed the order pursuant to the direction in the 2019. Lordship may kindly see the relevant para of
You
the
can't
collector.
read the relevant para unless you give a typed copy.
Illegible, my lord.
Completely illegible. I don't know.
Page
33 of the writ petition.
Starts at page 31.
Starts at page 31.
Give a copy.
I will, my lord.
Lordship, he has been, the Tahsildar and the collector have written to the government for a refund of 1,02,364 rupees out of 5,70,000 that he's claiming were deposited. That query was not put into auction. He had taken it on negotiation, your lordship. And this, he's disputing that he has never operated the query. But a committee was constituted and the committee on 30/9/2020 made a survey, your lordship, and has come to the conclusion that the petitioner had extracted 3987 cubic meter of black stone, your lordship.
That is the.
That is, and he's disputing that no one has not operated the query.
But in the counter affidavit, they have also not annexed.
But the expert committee consisting of Tahsildar and recognized persons, revenue inspector, and also the lessee was present, your lordship, when the inspection.
They will produce the committee report at least.
Not
Sir, you filed representation in 2019. You filed the writ petition in 2019 for disposal of representation. Your representation has been rejected. Your representation has been rejected. In
Not
2000.
my lords, collector, in consideration of my representation, directed the Tahsildar to refund the amount.
Part of the amount.
Now you are saying that they should produce the documents. They should not produce any document. They are not required because you approach the court belatedly after 9 years.
Not belatedly, since 2014, I have been pursuing, it has been disposed of in the year 2019.
You filed the writ petition in 2014.
14 months.
A writ petition filed in 2014.
During the time of the.
What is the date?
My lord,
When was the writ petition was filed in 2014?
WPC 14659 of 2014. I have annexed the order, my lord, in page 19.
Yes.
So was that filed for refund? That must have been filed for allowing you to operate.
Allowing to operate the query.
We'll see,
For
file the
allowing to
legible
operate.
copy of that impugn order.
Let a legible copy of the order dated 28/2/2020 bracketed annexure 3 to the writ application. Let it close, we filed by the petitioner by way of an affidavit, legible / typed copy. All right, by memo.
File it by way of a memo. Either you give a legible copy or typed copy. Please check carefully that there is no mistake.
2 weeks.
Maybe this repetition may be also tagged because all the documents are there in that repetition.
Which repetition?
WPC 14659 of 2014. This is the main repetition.
There's so many, let us tag everything. Page,
As a lordship, please, but this is important. This all the documents tagged in that repetition.
Give the number.
WPC 14659 of 2014.
False title declared. Except the contempt, I think otherwise.
Yes.
Item number 25.
Might I appear for the question? May please your lordships, my lord. The question which arises for consideration in this petition is whether GST could be levied on licensing services for the right to use minerals and its
Pardon, in this case, not. I need some time because he has challenged the already Supreme Court decided he has challenged again,
not again, my lord. This is a pending challenge.
Yes, so that I will want time because
in the affidavit they referred to the murder judge.
Inform him, I think he's coming from.
Calcutta.
Because the union opinion.
Okay, that is all right. But when you ask for time, since the council is coming from outside, if you would have informed it, maybe.
If I had been informed, my lord, I could have, my lord.
All right.
Otherwise, I have appeared from the one of the commission, but union evidence necessarily he has not filed any complaint. We have to lead that part also.
I would only replace my learned in subject to lordship's kind consideration. No, may I just make my submission so that my lord,
Yes, that if it is that, it is okay.
Subject to lordship's kind consideration. I leave it entirely to your lord.
Points you can say on which you insert this or that.
I leave it entirely to your lord.
I'm sorry, my lord, because
better we hear both of you.
Very well, my lord. And then, my lord,
can we understand that you have been put
can it be on the other side of the vacation, my lord, subject to your lordship's?
Yes.
January, any date subject to your lordship's pleasure.
All right. Yes.
Yes.
I can answer to the
Requested on behalf of the parties, this matter on. Yes.
Here.
8th.
8th January. 8th January. Well, can it be 13th, my lord, subject to entry? Can it be 13th? 13th?
What day is 13?
Well,
13th.
Well, I'm sorry, my lord, I'm traveling on lordship time and again. Well, 15th.
I don't think you can see January from here.
Well, January, my lord, 13th is Monday.
Yes.
That I know.
Yes.
My lord, can it be 16th, 15th or 16th? Whichever date suits your lordship.
Yes.
Well, I'm grateful, my lord. There's only enough intelligence to be my lord.
I'm sorry, my lord, I'm traveling.
Next time, please.
No, definitely.
I'm for opposite, but now 5 years.
Item 26.
Slight issue, lordship's kindly.
Here in this case, your lordship granted last chance to file the counter by the government on 12/8/2024. Your lordship directed to the government to file specific counter in regards to the annexure 6 of the report of the collector, saying that the encroachment made by the opposite party 568 records, and they have not filed their counter as on date.
Actually, we received the paradise comments, we are.
By way of last
We filed it in the course of the day.
Second last, we can give you. Last, in the first last we had given.
Today itself.
So now we can give second last intelligence.
They are in the office, your lordship, the counter is being drafted.
Right.
Counter is being drafted.
They've
Then
sent
you have to.
All right. Do it. Do it. Do it. Do it. We are granting time, itself. Bali.
Yes, Your Lord.
DGA appearing on behalf of the state has submitted that she has received the Parawai's comments and she shall be filing
By tomorrow.
the
Today itself.
affidavit
Don't take a risk.
by tomorrow. That's all. Let a copy of the counter affidavit be served upon the counsel for the petitioner by tomorrow. Post office this matter on 1 week.
The time for rupees 10 to 30.
So who's appearing, Mr. Tripathi or Ms. Patnaik?
I'm appearing.
All right. Rupees 10 to 19.
Rupees 10 to 30. The company, the successful resolution is
27.
great.
27. We'll file the additional affidavit next week. They have filed consolidated copy of the writ petition. We'll file our additional affidavit next week.
Hey, Lordship, please. There is earlier direction to file additional affidavit by today.
Requested on behalf of the by DGA. This is matter on 1 week. To file additional affidavit.
28.
Lordship, that's
28.
Right, additional affidavit is brought on.
This is not sufficient.
Let the additional affidavit be placed on record in file. Yes.
28.
So, Your Lordship, please to issue a notice on 20th November 2024. The person was not blacklist period is over, but they have indirectly, my lord, they have after selection, the holding you are previously blacklisted and disqualify my bid, my lordship. After selection, Your Lordship, please to issue notice on 20th November 2024 and to.
Madam Naidu is appearing.
Lordships, may I kindly turn to page 40.
Page 40.
Lordships. The last paragraph.
Yes.
In view of the above, your agency has been blacklisted from participating in the future tender of the OMDC for a minimum period of 1 year from the date of issue. So it's that is one part. Now your Lordship may turn to the judgment of this honorable court, which is just the next. Your Lordship will find it at page 56. This order was set aside and the matter was remanded again. So whether the period is for 1 year or not, it has not attained finality as yet.
So whether he is blacklisted.
Pardon, Lordship.
What is the advantage of this order passed by the?
Your Lordship, page 56, it was said because it was there was natural justice has been violated. Lordship, paragraph 20 of that judgment. It clearly says, in view of the facts and law, as this court.
Madam, he was blacklisted.
Lordships.
Now the order of blacklisting was set aside. And you were required to pass an order of arrest. You have not passed the order. Have you?
No, Your Lordship, I was not directed.
The concerned department, OMDC.
Concerned department was directed.
For the endowment.
I am appearing for the endowment, Your Lordship.
All right. So are you saying that since the order of blacklisting has been set aside, he should not be, I mean.
No, Lordship, it was even though the order for blacklisting was set aside, the matter was remanded to be heard again.
Yes.
And that order has not attained finality. Whether it would be for the period, it should be 1 year. Whether it would be more, it's unknown. And he had not disclosed this at the time when he had applied for tender.
All right. As on date. As on date, whether he has been blacklisted or not.
Lordships, that is the question.
That is the question. You answer, madam.
Your Lordship, that since the order has been set aside and sent back, so until a final decision is taken by the competent authority, we cannot take a call.
All right, madam, if you don't do it, then your client may have to suffer.
And now in the meanwhile, a fresh person has been tender has been.
We may initiate. Have you filed affidavit?
Lordships, I have not filed affidavit.
File your affidavit.
Lordships,
We may initiate contempt proceeding.
Lordships.
Because that will amount to ignoring this court's order.
Lordships, I'll file a detailed affidavit.
2 weeks' time is allowed for the opposite parties to file a counter affidavit. Opposite party number counter affidavit. This is not.
Oblige.
My lord, maybe pardon. May I pardon to mention, my lord? No, item number 2, my lord, my only senior was there, Mr. B. Rao was there. Unfortunately, neither my associate nor I could be present before.
What has happened in that?
It has been disposed of, non-appearance was missing. That has been seen.
Nobody there.
All right, your parents.
High level.